Thank you, Chairman Grassley, for calling this hearing. It is my hope that this will be the first of several hearings on the proposed reforms to the patent system, and that we will have an opportunity to hear from as broad a range as possible of the folks who will be affected by the proposed changes, including some of the critical voices not on today's panel, which I think centrally includes small businesses who rely on patent protection for attracting investment, especially in the bio and pharma and material spaces, and the venture capital community that invests in them. While I congratulate my colleagues on their bipartisan effort, this is not a bill that I can support. While it has made progress and is less bad than H.R. 9, currently under consideration in the House, there are still, in my view, two central concerns that I have in reviewing this act. First, the reforms in this bill that will make it harder to enforce patents are not targeted towards trolls, but will affect all patent holders. What this will mean in practice is that small investors, small inventors, startup businesses taking the biggest risks will be potentially hit the hardest by the proposed litigation reforms. Second, the bill contains nothing to encourage the innovation that our patent system is designed to support. In particular, there's nothing in this bill to remedy the well-documented abuse of post-grant proceedings. And I greatly appreciate the comments of my colleagues, Chairman Grassley and Senator Coons, who have expressed a desire to incorporate improvements in these areas in markup. Allow me to briefly elaborate on both points, if I might. I'm starting with the bill before us today. Our panelists have described some truly egregious conduct by trolls, including companies sending thousands of letters to small businesses or retailers, and a company suing based on nearly expired patents. Yet none of those circumstances are limitations actually embedded in the provisions of this bill. Instead, it changes the rules for all patent holders. Specifically, the provisions on heightened pleading requirements, delayed discovery, enhanced fee shifting do not even attempt to distinguish between patent trolls and the startups and small businesses across America that are potentially creating jobs and making new discoveries and delivering life-saving cures. We can make that distinction, and we must. The patent system is simply too important to make speed the ultimate goal of our efforts rather than accuracy. Several of you have described it as a Rubik's Cube, a complex system where there is a real risk of unintended consequences. And I think, frankly, the point about post-grant review makes that abundantly. Don't just take this from me. I have a letter, and Mr. Chairman, I'd ask permission to enter this into the record from the National Venture Capital Association, which does...
Objections to order.
Thank you. Which does speak on behalf of all of the venture capital community, that speaks to the significant unintended consequences that we may face. And I quote, "It's important to recognize a patent is only as strong as the owner's ability to enforce it and the awareness of others of that ability. If the bill as written were to pass, NVCA believes both of these parameters would be impaired, making it more difficult to invest in early-stage companies working on life-saving cures or significant breakthroughs." To further understand these views, I encourage any of my colleagues or staff to watch the hearing and associated testimony from the recent Small Business and Entrepreneurship Committee hearing chaired by Senator Vitter. In that hearing, we heard from Rachel King, CEO of a small biotech company developing potentially life-saving treatments for blood cancers. She testified, quote, "If the ability to enforce patents become limited due to excessive lawsuit filing requirements or undue delays, third parties would be less likely to invest in or license our technology, and major sources of R&D funding would dry up." We also heard from Robert Schmidt, co-chair of the Small Business Technology Council, who expressed fear that weakening patent laws would only benefit large, dominant firms in maintaining their market power. On the second issue, there is nothing in this bill that helps inventors attract investment to find new cures or disrupt current technologies. And I'm pleased to hear Mr. Chandler's testimony in which he acknowledged that recent abuses of post-grant review is outrageous, and the expressed concerns by Mr. Rhodes and Mr. Haddad that these need to be addressed. My Strong Patents Act, which Senator Vitter has joined Senator Durbin, Hirono in co-sponsoring, really would address IPR abuse. And I would be interested, if I might, Mr. Chairman, in hearing Mr. Haddad speak to what are the changes in IPR and PGR proceedings that you would like to see incorporated into the bill. Since Mr. Rhodes has already had an opportunity to address that, I'd be interested, Mr. Haddad, in how you see the changes needed to really deal with this issue.
Thank you, Senator Coons, and thank you for your concerns and considerations of these issues in your Strong Patent Act. Many of the proposals that I brought up have analogous provisions in the existing text of the Strong Patent Act. There are refinements, and there's, as thinking has continued to really target this to the abusive conduct and really tailor it in a way that makes sense. I mean, as I mentioned, having the equivalent standards as district court, giving an alternative to amending claims through this reissue or reexamination, and then providing some basic fairness and equity in terms of the type of information you can introduce. Those three areas that I said, and I think Mr. Rhodes agrees with, are areas that would be areas of focus going forward in my mind.
Thank you, Mr. Haddad.
Thank you.
Thank you, Mr. Chairman.